Hello, everyone, and welcome to another episode of the Forge of Freedom podcast. I'm your host, Alex Ooley, and this is episode 172 of the Forge of Freedom. Today, I have a couple of topics to discuss with you. The first is, we'll address relatively quickly, is about an update, some good news from the federal government regarding the process to restore your right to keep and bear arms if you are prohibited under federal law from possessing a firearm due to a federal prohibition. The second topic is an interesting case out of Indiana, Turner v. State. It just came down from the Indiana Supreme Court, and it deals with whether or not the defendant who asserts self-defense gets the benefit of hindsight in their assertion of self-defense. And it's a really interesting case. I'll give you my thoughts here right at the outset. I agree with the court's conclusion with the outcome of the case, but I disagree with their rationale, and we'll talk about that here more in just a little bit. But first, with respect to federal law and the ability to get relief, or what a lot of people would call an expungement at the state level. So in Indiana, if you commit a crime and a certain period of time goes by, many crimes can be expunged, that is, sealed or essentially deleted from your record, from your criminal history. And if the process is done in the proper way, that can restore your right to keep and bear arms. But what if you're convicted of a crime under federal law? Well, there has been a provision to restore your right to keep and bear arms, or to seek relief from the disability created by federal law. And that relief is found under federal law. It's 18 United States Code 925C. And I'm going to put that up on the screen here just momentarily. And this law has been on the books for quite some time. I believe it was part of the Gun Control Act of 1968. So it's been on the books, it's been part of federal law for over 50 years. And it says that a person who is prohibited from possessing, shipping, transporting, or receiving firearms or ammunition may make application to the Attorney General for relief from the disabilities imposed by federal laws with respect to the acquisition, receipt, transfer, shipment, transportation, or possession of firearms. And the Attorney General may grant such relief if it is established to his satisfaction that the circumstances regarding the disability and the applicant's record and reputation are such that the applicant will not be likely to act in a manner dangerous to public safety, and that the granting of the relief would not be contrary to the public interest. So there you have it. 18 USC 925C essentially provides for what is much like an expungement at the state level. And many states have expungement processes. Some do not. Indiana does. But if you are convicted of a federal crime and you're prohibited from possessing a firearm as a result of that, or ammunition as a result of that conviction, you would think you could get relief from that disability pursuant to this statute. But in the early 1990s, the Congress, primarily through the efforts of Chuck Schumer, defunded this particular provision. So this statute references the Attorney General, but the DOJ, through the Attorney General, delegated the authority to enforce or enact this provision of federal law to the ATF, to the Bureau of Alcohol, Tobacco, and Firearms, and Congress deleted the funding to enact or to enforce this statute. So if you have a conviction, a federal conviction, you have been unable to avail yourself of this statute for over 30 years. And it was just announced last week, I'm recording this on Sunday, March 23rd, 2025, last week that this process should be basically given new life. It should be, the ATF should start to allow these applications to take place, and they should process those applications. Now, I don't know exactly what that's going to look like just yet, but that process should be coming to light, coming back on the rails before too long, I would hope. Prior to this announcement, the only hope you had at restoring your right to keep and bear arms if you had a federal disability from possessing a firearm was, as a result of a federal conviction, was a presidential pardon. So there was basically no hope even if you were convicted of a white collar crime, a nonviolent crime, you could not restore your right to keep and bear arms because this statute was unfunded, or the mechanism to enact this statute was unfunded. So that's great news for those of you out there who had the only the long shot of a presidential pardon. You may now have this provision of federal law to restore your right to keep and bear arms in the near future. So that's great news. Now, the next story, this brings us to Indiana and self-defense law in Indiana in particular. But I want to talk a little bit just at the outset about self-defense law more broadly. So Indiana has the self-defense statute, and I'll pull that up here in just a little bit. Many states have their own self-defense statute, or I should say all states, and they vary quite a bit. Each of them is unique and has their own language and own provisions. And there are many people out there, the likes of Andrew Branca, who wrote the Law of Self-Defense, Massad Ayoob, who runs the Massad Ayoob group and the popular Mag 40 class, who teach broad principles about what those various state statutes encompass sort of universally. What standards have to be met in self-defense, whether you're in Indiana or you're in Florida or in some other state. And Massad Ayoob, he says that you have to be facing an immediate, otherwise unavoidable threat of death or grave bodily harm to me or another innocent person. Those things have to be present to lawfully use force in self-defense. And Andrew Branca, on the other hand, in the Law of Self-Defense, encompasses a lot of the same concepts, principles, elements. He says that the threat has to be imminent. The person acting in self-defense has to be innocent. You can't have been the initial aggressor. Your response has to be proportional to the threat that you're facing. You have to avoid the use of force if at all possible. Of course, there are exceptions to that in states that have castle doctrine and stand your ground. But again, we're talking about broad principles. And then your actions have to be reasonable. And this case in Indiana deals with what goes into the analysis of whether or not someone's actions were reasonable. And ordinarily, there are two components to the reasonableness inquiry. There's the subjective component, and there's the objective component. The subjective component being, did the person, knowing what they knew at the time, what they heard, what they saw, what they knew about the threat, did they act reasonable based on their beliefs? And then there's the objective component, which is where the jury typically is asked to put themselves in the shoes of a hypothetical reasonable person. And would that hypothetical reasonable person have done what the defendant did, the person who acted in self-defense did, knowing what they knew at the time? And when they're making that objective inquiry, they cannot say that, oh, there's this evidence that happened after the fact that the defendant didn't know, and that changes our analysis. The question they're asked is whether or not, knowing what they knew at the time, were their actions reasonable. And so they can't act with the benefit of hindsight. They can't analyze the defendant's actions with the benefit of hindsight, saying that, oh, well, these things are true now. We know them in the comfort of the courtroom. They've been presented to us through the prosecutor and the police, and that because we know this information now, judging the defendant's actions then in that moment, they were unreasonable. That's not allowed. But the question that this case in Indiana asks is, okay, we can't second guess the defendant's actions based on hindsight, but can the defendant get the benefit of hindsight? And the court says yes in this case. Again, the case is Turner v. State, and I'll put it up on the screen here if you're watching the podcast by video, you can see the case. I pulled it from Justia, which is a popular legal reference website. And the case is posted there, available for download as a PDF. It's Indiana Supreme Court case number 24S-CR 147. And I'm just going to read briefly the summary of the opinion here, because it has some interesting facts in it, and it bears on self-defense analysis is heavily fact dependent, and small details matter. But here's at the beginning, this is the opinion by Justice Moulter. It says, this is a case about a good guy with a gun shooting a bad guy with a gun when the only choices were to shoot or be shot. Antonio Turner was one of 3 students studying organic chemistry at a classmate's home tucked away in a quiet neighborhood just outside of Indianapolis. While they were studying, the classmate's jealous love interest, Daquan Briscoe, repeatedly called her. And when he learned Turner was at her home, Briscoe twice threatened to pull up on Turner to attack him, which Turner heard over the speakerphone. Shortly after hearing the threat, Turner walked outside to his car, and moments later he sensed that the unfamiliar car screeching towards him down the sleepy street was an ambush. Since he didn't have time to reach the house and had nowhere to hide, he turned while running and fired 4 shots into the car, wounding Briscoe. Turner fired based on his intuition. He didn't recognize the car, couldn't see through its darkly tinted windows, and wouldn't have recognized Briscoe if he saw him. But that intuition proved prescient. It turns out Briscoe was aiming a handgun to shoot Turner just before Turner began firing. Because Turner shot Briscoe before Briscoe shot Turner, Turner is the defendant rather than the victim in this case. The state charged Turner with battery by means of a deadly weapon, a level 5 felony. And following a bench trial, the magistrate judge convicted him. Yet the judge agreed with Turner that in hindsight, it was necessary for Turner to fire at Briscoe to avoid being shot. But the judge rejected Turner's self-defense justification because without the benefit of hindsight, it was objectively unreasonable for Turner to fire at a car into which he couldn't see. Turner made the best choice, the judge explained, and it was unfortunate that his only choices were a felony or a funeral. But that paradox followed from the objective reasonableness standard governing Indiana's self-defense law, and the law gave the judge no choice but to convict, he believed. Fortunately for Turner, that isn't how Indiana's self-defense law functions. To be sure, the judge was correct that the self-defense statute justifies using force when the defendant's actions are objectively reasonable in the circumstances, and many cases explain we don't use hindsight to second guess the reasonableness of the defendant's decisions in the heat of the moment. But this case presents a question of first impression in Indiana. Do we deprive defendants of the benefit of hindsight when it reveals their conduct was necessary in self-defense, even though that necessity wasn't fully transparent in the moment? The answer is that we do not, and we base that answer on a sentence in the self-defense statute that our Indiana appellate courts have never interpreted before, which says, "No person, employer, or estate of a person in this state shall be placed in legal jeopardy of any kind whatsoever for protecting the person or a third person by reasonable means necessary." Because the trial court concluded that Turner's conduct was necessary in self-defense, the statute justified the shooting, and we vacate the conviction. So here we have the court, the trial court, and the Supreme Court saying that Turner's actions were not reasonable knowing what he knew. So the subjective analysis, he fails. And if any element of a self-defense claim fails, the self-defense claim in its entirety fails. But it turns out objectively that Turner's self-defense claim was legitimate, that in fact the attacker did have a firearm, even though Turner didn't know he did, that in fact the attacker was Briscoe, the person who had made the threats, even though Turner couldn't see into the window. And that in fact, when you get into the details of the case, that apparently Briscoe had the firearm pointed out the window toward Turner when he was shot. But Turner didn't know any of these things. And so only in hindsight do we know that his actions were objectively reasonable. But the court here, the trial court and the Intermediate Court of Appeals and the Supreme Court all said subjectively, knowing what Turner knew, his actions would not have been justified based on the subjective reasonableness analysis. But I think that the court overcomplicates things here. And I want to pull up the statute, first of all, from Indiana. This is the Indiana General Assembly website, and I have pulled up on the Indiana General Assembly website Indiana Code 35-41-3-2, which is the statute entitled Use of Force to Protect Person or Property. And the general self-defense provision is under subsection C. Now, there are other provisions, including Indiana's Castle Doctrine, included here, and in a number of other self-defense provisions. But the general self-defense provision is under subsection C, and it says, a person is justified in using reasonable force against any other person to protect the person or a third person from what the person reasonably believes to be the imminent use of unlawful force. However, a person is justified in using deadly force and does not have a duty to retreat. That's the stand your ground provision in Indiana. If the person reasonably believes that force is necessary to prevent serious bodily injury to the person or a third person or the commission of a forcible felony. And then this is the part that the Supreme Court utilizes in coming to their decision. It says, no person, employer, or estate of a person in this state shall be placed in legal jeopardy of any kind whatsoever for protecting the person or a third person by reasonable means necessary. And that's the provision that the Supreme Court says has never been interpreted by Indiana courts, or at least by the Indiana Supreme Court. And that provision I've always considered just to be a statement of policy. But here the court is saying that because the person here, Turner, acted in a way that was objectively reasonable, that he cannot be placed in legal jeopardy of any kind, even though his subjective rationale for acting in self-defense in the moment would not have supported a self-defense claim. Now, like I said at the beginning, I agree with the outcome of this case. I agree with the court's decision. I agree with the judgment, i.e. that the trial court mistakenly found Turner to be guilty and that the conviction and the judgment should be overturned. However, I disagree with the rationale. I think that the court here overcomplicated the analysis, and I think that it stems primarily from probably a lack of understanding the dynamics of a self-defense situation. I think that Turner, based on the facts that have been presented to the court and have been repeated here in the Indiana Supreme Court's opinion, support both the subjective reasonableness of Turner's actions as well as the objective component. Here, Turner, he overheard a threat on the phone, repeated calls to the ex-girlfriend. He heard a car revving up his engine after this person had said he was going to confront Turner and pull up on him, which apparently is lingo for a drive-by shooting. And he hears this car coming down a quiet street and reasonably, in my opinion, believes that it's Briscoe, despite the fact that he can't see him and despite the fact that he can't see that the person has a firearm. Because he had just overheard this call. It's a street with little traffic, and this person is driving aggressively, apparently coming right toward Turner. I think that both subjectively and objectively, a reasonable person would have believed that that was Briscoe and that Briscoe intended to cause Turner harm, meeting both the general standards for self-defense as portrayed by Masad Ayub, or outlined by Masad Ayub and Andrew Branca, and also meeting the general self-defense statute under Indiana without even getting to the last sentence about not being placed in legal jeopardy. So, again, I agree with the court's decision. I disagree with the rationale. Now, I want to share the concurring opinion here because I actually agree with the concurring opinion from Justice Goff. And I'll link to the full opinion at Justia as well as some other commentary that I've seen about this case on Bearing Arms and from Guy Relford. Both are very good. I'm not celebrating this decision like many are because I think it overcomplicates the analysis and may cause some confusion in the future. But I do, like I said, agree with the outcome, the judgment being overturned. I believe that Turner should not have been convicted. Now, just as an aside, you may have caught the fact that Turner had a bench trial, so he did not. He waived his right to a jury trial in Indiana. You have a right to a jury trial when you're charged with a felony. You have to waive that right to a jury trial to have a bench trial. And apparently he waived that right and because this is, maybe he thought that this is an issue that the judge, it might be too complicated for a jury, that this is a better left up to a judge. That's an interesting decision to make. And it's one actually that I discussed recently in a Gun Digest article. So I'll link to that article as well if you have an interest in how to think about whether to have a jury trial or a bench trial. But getting back to the opinion, this is the concurring opinion from Judge Christopher Goff. And he says, should the merits of a self-defense claim depend on the defendant having acted with knowledge of the justifying circumstances, even if his conduct is objectively justified in hindsight? Facing this very question well over a century ago in 1892, this court held that a defendant who acted out of no apparent necessity to preserve life or limb may not interpose the defense of self-defense simply because it subsequently appears that there was actual danger of which he was at the time ignorant. The court today reaches the opposite conclusion, holding sua sponte that under an obscure and otherwise dormant provision of our self-defense statute, Turner's use of force was justified not because his belief, that's the subjective belief, that he was about to be shot was reasonable, but because the belief was correct and force really was necessary to protect himself. Defendants like Turner, the court opines, enjoy the benefit of hindsight when the evidence reveals their conduct was necessary in self-defense, even though that necessity wasn't fully apparent in the moment. In my view, the statutory provision on which the court relies is less than clear, and its novel interpretation, I fear, will create uncertainty in the law, leading to potentially harmful consequences. What's more, even if I were to agree with the court's interpretation, its holding rests on a flawed premise. There's simply nothing in the record to support the conclusion that Turner avoided being shot by Briscoe only by shooting Briscoe first. For these reasons, and because I believe the court's novel statutory interpretation is entirely unnecessary to give Turner relief, I concur only in the court's judgment. Finally, the court's novel interpretation of the statute, in my view, is entirely unnecessary to give Turner relief. And this is where I completely agree with the concurring opinion here. Indiana's self-defense statute establishes both an objective and subjective standard to evaluate the reasonableness of a defendant's belief that force was necessary to protect against the imminent use of unlawful force. Under the subjective standard, the defendant must have actually believed force was necessary. And under the objective standard, the defendant's belief must be one that a reasonable person would form given the circumstances. Applying these standards, the circumstances here, in my view, clearly justify Turner's actions. He knew that Briscoe owned a gun. He overheard Briscoe make angry, profanity-laced remarks to his study partner over the phone. Briscoe threatened to pull up on Turner, which Turner understood to mean that he'd be coming to harm him. And not long after that tense exchange, a vehicle sped up to Turner, its engine revving and tires squealing, just as Turner had walked away from his own car parked in the cul-de-sac of a suburban residential neighborhood. Though Turner couldn't definitively say whether it was Briscoe in the car or whether Briscoe pointing a gun at him, as the trial court stressed, the law didn't require him to. The touchstone of self-defense is reasonable belief, not absolute certainty. And Turner testified that given the circumstances, he believed it had to be Briscoe pulling up, that there was no way it wasn't. In short, Turner was acting based on threats alone, as the trial court found, but rather, in short, Turner wasn't acting based on threats alone, as the trial court found, but rather on the circumstances before him at the time which he reasonably believed placed him in grave danger. And I think that the concurring opinion here is exactly correct, that the court, the majority opinion, just gets this objective analysis incorrect because they didn't fully understand the dynamics of the self-defense situation. And that's why it's so important. And I'm hearkening back here to Masad Ayoub's class, Mag 40, where he talks about can't CYA. And most people think CYA means cover your behind, right? But CYA, Masad Ayoub says, can you articulate? Can you articulate why you did what you did at the time, knowing what you knew? And can you articulate the reasonableness of your actions? And that requires understanding the nuances, the elements of a self-defense claim. And that's why I encourage people to read Law of Self-Defense by Andrew Banker, listen to Masad Ayoub, read his books, In the Gravest Extreme, Deadly Force. He's got a number of books. Take his class, Masad Ayoub's Mag 40 class, if you can, or at least the Mag 20 class, and really understand the elements necessary to be present for lawful use of force in self-defense because your life depends on it. If you act in self-defense and you save your life, that's one thing. But if you do so unlawfully, you may be in prison for the rest of your life. Thankfully, the court came to the right conclusion here, but at least I believe they came to the right conclusion for the wrong reasons. Tell me what you think in the comments. Read the opinion for yourself. Like I said, I'll link to the opinion itself along with some other commentary on the opinion. Let me know what you think. You can find us, as always, on YouTube, Facebook, X, and Rumble. I always try to respond to all the comments in those places. You can also find us on just about all the most popular podcast streaming platforms. In fact, I think the Spotify has comments there as well. I'm happy to respond to any comments or thoughts that people have about the case. Let me know what you think. As always, you can find us on all those places I just mentioned. If you remember or have the time, I'd always appreciate a like, subscribe, review. That helps us reach more people. It helps us with the algorithms. And as always, remember, you are the Forge of Freedom.